of Kentucky, Kentucky's Bill of Rights, Section 1 through 26. Most of Kentucky's 26 Bill of Rights actually is self-evident, self-apparent. You can understand it for yourself. But there are some actually, Section 19, 20, Section 9, and Section 12, which had caught me off guard a little bit. Section 9 is about libel. Essentially, nobody gets prosecuted for libel anymore. Truth is a defense for libel. The biggest debate here is about whether the judge could instruct the jury what to do, what not to do. You don't want to have any type of undue pressure for the jury, so the jury is supposed to be selected, have all the comforts, and they make their own choice, and then the judge sentences them, so the jury can make whatever decision that they want to make without the sentencing. And so, at least in Kentucky. But a lot of these cases come over, compare and contrast. So you had Peter Zenger, the trial Peter Zenger case in 1735, in the very beginning of the Republic of America. The jury ignored the judge and said that truth is a defense against libel. So the judge said no, but the jury said yes, and therefore Peter Zenger was a free man. So Section 9 appears in all four constitutions in Kentucky. It was originally borrowed from the Pennsylvania Constitution of 1790. Last time it was used, the U.S. Supreme Court in 1966 declared that Kentucky's definition of common law criminal libel was unconstitutionally vague. And that's Ashton v. Commonwealth. And it is really vague. I mean, listen to what it says. It says, in prosecutions for the publication of papers investigating the official conduct of officers or men in a public capacity, or where the matter published is proper for public information, the truth thereof may be given in evidence, and in all indictments for libel the jury shall have the right to determine the law and the facts on the direction of the court, as in other cases. I put the window in actually because it's snowing, but I guess you can't really see it. So I'm just kind of showing myself to the world for no apparent reason. It's a beautiful shot, and maybe I'll think of something else later on. But so that's Section 9, and then Section 10, no, Section 12 was confusing to me. And Section 12 is indictable offense not to be prosecuted by information. Exceptions. No person for an indictable offense shall be proceeded against criminally by information, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger, or by leave of court for oppression or misdemeanor in office. No idea what that means, so let's just go with Robert M. Ireland's book, the Kentucky State Constitution. So Section 12, indictable offense not to be prosecuted by information. Exceptions. This provision, which was taken from the Pennsylvania Constitution of 1790, effectively requires that those whom the Commonwealth wishes to formally accuse of serious crimes, except mostly those committed when in wartime military service, must be charged by grand jury indictment. And information is a charge brought by a prosecutor alone without grand jury involvement. Okay, so if the prosecutor just says the grand jury didn't indict him, but I'm just going to put up this fucking shit by myself, that's an information. Okay, in Kentucky, a grand jury consists of 12 citizens selected at random from the pool of individuals summoned to jury service at the beginning of each term of the local trial court, aka the circuit court. A concept adopted from the English system of criminal justice, the grand jury determines whether there is probable cause to charge or indict someone with the commission of a serious crime, usually termed a felony. Military crimes are accepted because they are traditionally tried by military courts. The grand jury offers individuals suspected of crimes an additional protection in that it may choose not to indict someone whom a prosecutor wishes to indict. So the prosecutor can indict somebody for a felony and they can go on with it, but they, generally speaking, you have to have a grand jury who indicts them. And so this section is saying that it can't be just by information. You actually need, Section 12 says you have to have a grand jury indict you for a felony. That's what the Section 12 is all about. And the exceptions is military crimes. They're accepted because they're traditionally tried by military courts. So, you know, if the crime happened in Fort Knox, then Fort Knox personnel would take care of that crime. Military crimes are accepted because they're tried by military courts. A grand jury offers individuals suspected of crimes an additional protection in that it may choose not to indict someone whom a prosecutor wishes to indict. Critics of the grand jury argued that this protection is limited since only the prosecutor presents evidence to the grand jury, which consequently usually does what the prosecutor wishes. So they say it's limited because it only shows what the prosecutor shows, and it only does what the prosecutor wishes, but it is a step. 12 people have to look at the case and say, yes, a felony occurred. Yes, this is a felon. We need to make sure we proceed with the indictment and get a crime, and that's important. I think the grand jury is an important exception, is an important mechanism into our democratic system. So there have been few appellate cases considering Section 12, and most of these concern appeals from conviction by defendants who argued that the crimes for which they were convicted required grand jury indictment, a contention that usually proved unsuccessful. Wackenthaler v. Commonwealth, 1926, exemplifies this tradition. In the case, the convicted defendant fruitlessly argued on appeal that the crime of unlawful possession of liquor was an offense for which grand jury indictment was necessary. So it basically saying that people don't fucking, nobody is actually getting in trouble for this shit. So if the prosecutor was to just go ahead and throw out some fucking charge with no grand jury, a felony, if someone says you're a murderer, a prosecutor says you're a murderer, and they put you on trial, and then you get tried and you get thrown in jail, Section 12 definitely fucking covers that up. It says that for all felonies, it has to go through a grand jury. You can't, by information, you can't just say, the prosecutor can't just hearsay that person is guilty and then the whole fucking proceedings goes along because he's just a fucking asshole. The grand jury has to indict somebody for a felony. And so the one case that they said that it failed on, the man, Wackenthaler v. Commonwealth in 1926, he exemplifies the tradition. So in the case, the convicted defendant fruitlessly argued appeal on the crime of unlawful possession of liquor. So in 1926, they said that he had liquor, he was a criminal, so therefore he was a felon. And he says, that's bullshit, you need to give me a grand jury. And so in hindsight, if the grand jury would have checked it out, they would have said that liquor possession is not a fucking felony. You're not going to get your entire life fucked up a felon. You're not, what are felons? They're murderers, they're rapists, they're war criminals, they're pedophiles, they're, grand theft, arsony, whatever, fucking lighting shit on fire and stealing big old fucking shit. They're bad fucking criminals. They're people that really fuck over a lot of fucking people. That's what a felon is. And so a person who has liquor, that's not a felon, and there should be a grand jury indictment before any felony. So Section 12 is important. It hasn't been used. So actually I'm going to read it again because I'm impressed by Section 12. Indictable offenses not to be prosecuted by information. Exceptions: no person for an indictable offense shall be proceeded against criminally by information, so just of a prosecutor by himself, except in cases arising in land and naval forces, in the militia, when in national service at time of war, public danger, by leave of court for oppression or misdemeanor in office. So the only way that it can be proceeded against you is by leave of court for oppression or misdemeanor in office. So if it's somebody in office and there's a misdemeanor, they might be able to criminally indict you in service. So if there's actual wartime conditions going on, in time of war, public danger, if there's a rebellion going on, you can call people guilty of some things without a grand jury. But except for those exceptions, no person for any indictable offense shall be proceeded against criminally by information. The prosecutor, if all they have is just information and they don't have any evidence, you have to go to the grand jury. The grand jury then says the indictment has been issued, and now we have to go through the whole show trial of criminal proceedings because there could be a felony charge. So the felony charge actually ups the rights that a person has in terms of getting a grand jury verdict, and every felon case should go before the grand jury. I won my grand jury battle. They said I was not a felon and that I was not going to go to prison for 5 years. That's what the LMPD had put a grand jury. They put a felony on me, assault a police officer, and so it had to be presented to the grand jury, and the grand jury believed me, and they knocked it down. So Section 19 and 20 also confuse me. So Section 19 is ex post facto law or law impairing contract forbidden rules of construction for mineral deeds relating to coal extraction. I'm just going to read the explanation of it because it's really dense and it's hard to understand the exact words. So the first paragraph of this section appears in each of the previous 3 constitutions with slightly different wording, borrowed originally from the Pennsylvania Constitution of 1790. The framers of the current Constitution inserted the obligation of the language of the federal Constitution before contracts and change made to enacted. The second paragraph was added by an amendment approved by the voters in November 1988. So there's a whole nother paragraph that was added by the voters. So by amendment, this actually, the section 19, the second part was enacted by voters. So it's actually got more democratic legitimacy than most of the other laws out there. So although many informed persons at the time of the drafting of the first state constitution believed ex post facto laws to include retrospective laws that concern civil, ex post facto, I guess that's after the fact. So if somebody steals somebody's Twinkie, you can write a law. Anybody who steals Twinkies will be put to death. But if you wrote the law afterwards, then it doesn't matter because it was ex post facto law. And that's section 19 is ex post facto law or law impairing contract forbidden rules of construction for mineral deeds relating to coal extraction. So although many informed persons at the time of the drafting of the first state constitutions believed ex post facto laws to include retrospective laws that concern civil as well as criminal acts, the Kentucky judiciary has held that the state constitutional prohibition only applies to penal and criminal legislation. Henderson and Nashville Railroad Company versus Dickerson, 1856. Such decisions are in accord with the U.S. Supreme Court interpretation of the federal prohibition against state ex post facto laws, Calder v. Bull, 1798. However, the Kentucky Court of Appeals has ruled that a statute cannot retroactively make a person civilly liable for the act of murder for which, when committed, there was no liability. The reasoning was that the retrospective nature of the statute partakes of the obnoxious spirit of all ex post facto legislation in authorizing vindictive damages. O'Donoghue versus Aiken, 1866. The prohibition also applies to retroactive judicial changes of the rules of evidence that make it easier to convict someone of a crime at the time of the trial when it would have been at the time of the commission of the alleged crime. Commonwealth v. Brown. However, Kentucky courts may use a conviction obtained before the effective date of the Commonwealth's multiple offender statute to determine whether someone convicted of driving under the influence of alcohol was a multiple offender. Commonwealth v. Ball. This is just so fucking confusing. Cases concerning Kentucky's Contracts Clause usually also involve the Federal Contracts Clause, which may well have been the model of the state provision. The federal constitutional prohibition against state impairment of the obligation of contracts stemmed directly from a desire to protect creditors whose contractual rights had been impaired following the Revolutionary War by state debt relief laws that required creditors to accept in the payment of debts paper money of less value than the gold and silver coin that had been loaned out. Though it is not clear whether the drafters of the Kentucky Constitution also had this purpose in mind when they adopted language similar to the federal provision, some of the earliest and most controversial judicial pronouncements on the Kentucky Contracts Clause concern creditors' rights. In the cases of Blair v. Williams, 1823, and Lapsey v. Brashears, 1823, the Court of Appeals held Kentucky's debt relief law was unconstitutional, therefore setting off a firestorm of outrage that resulted in the creation of a rival Court of Appeals. The Court of Appeals, like the U.S. Supreme Court with regard to the federal provision, Dartmouth College v. Woodward, 1819, enlarged the ambit of the state contracts clause by making it applicable to corporate charters when it held in City of Louisville versus University of Louisville President, 1855. That the legislature had no power to annul, alter, or impair the charter of a private corporation. That's what? It says that the legislature had no power to annul, alter, or impair the charter of a private corporation, which is bullshit because we actually saw in section... I think it's like section 5, something at the very beginning. Section 5, no religious freedom, no. Section 4. Section 3. Section 3, men are equal, no exclusive grant except for public services, property not to be exempted from taxation, and grants are revocable. So if you give a grant, you can take away a grant. So you can take away the contracts. But it's saying that legislator here had no power to annul, alter, or impair the charter of a private corporation. So they can't annul, alter, or impair it. So they can't undo the charter of their own charter, but you can revoke the whole fucking thing. So you can't alter it or impair it, but you can revoke the whole damn thing. It says, However, since the Civil War, as in the case of federal prohibition, Kentucky's contracts clause has largely ceased to be an effective weapon against state regulation of the economy, as the courts have more narrowly construed the ambit of the clause and simultaneously enlarged the state's regulatory powers. See, for example, Commonwealth versus Covington and Cincinnati Bridge Company, 1893.